The guardian ad litem problem is rampant, historical, and a matter of historical reality, not debate. The guardian ad litem panel consists of a group of people that owe their selection to, in large measure, the presiding judge, and in large measure have some connection thereto, extended or otherwise. Guardian ad litem represents, in theory, the best interest of kids and is a statutory creature that must exist and should for circumstances where, for example, two parents cannot, are not in a position to understand and act to serve the best interest of kids. One can theorize two parents who have become addicted to heroin. We can all agree that we need somebody else to figure out and represent the best interest of those parents' children. The guardian ad litem system in this way is a necessary thing. We need to have it. It's not a question of whether we need to have it, it's how we have it. And in that regard, we have big, big problems. When we have a guardian ad litem panel that is identified, selected, and where individual appointments are made on the basis of a relationship with the individual judge, and where these people become parties to a litigation overseen by a presiding judge, it should surprise no one that we are not going to have a system that lends itself to enforcement of the legal duties that are clearly attached to becoming a guardian ad litem. And we are not going to have a system where guardian ad litems feel the need to conduct themselves in conformance with the various laws and standards which they are undeniably beholden to. And that's what we have. It is simply silly, now that I understand the system, that anyone would expect the guardian ad litem system as it presently exists to function in any way, in any sincere way. It's simply silly to conceive of the guardian ad litem system as it presently exists and not understand that there are going to be big-time problems with guardian ad litems, and specifically guardian ad litems being used not for their proper purpose, but by one party or another to effectively become a surrogate litigant for one parent to a litigation. The system as it presently exists lends itself to a party buying another party to be involved in the litigation, to lend their voice, warranted or otherwise, in conformance with the law or otherwise, to what that parent is saying, to make a one-on-one a two-on-one. That is the stark reality. We can all agree that should not be the case. Making the problem worse is that guardian ad litems who are invited to assume that role, to profit at the expense of abdicating their legal duty to truly understand the best interest of their clients, minor children, by definition, in a difficult circumstance, by definition, vulnerable children. The weak of the weak, if you will. Guardian ad litems who may be so unscrupulous as to be willing to sell their souls to become, in effect, a surrogate litigant for one parent trying to attack another parent, doing so by weaponizing children. A guardian ad litem so unscrupulous and so selfish, and frankly so desperate for work because they may or may not be totally incompetent and otherwise incapable of making an income, is absolutely in no position in the present iteration of the system to fear at all any kind of legitimate consequence, because after all, who's going to hold them accountable? Their buddy who appointed them? Silly. And that's exactly what we have. The guardian ad litem, in my case, makes a mockery of the system. It makes a mockery of a law license. It makes a mockery of the American Bar Association standards of conduct for a guardian ad litem. Competent, he's never heard of them, much less studied them. It makes a mockery of the clear obligation of independence that is articulated in Family Court Rule of Practice and Procedure 35 and 36. He makes a mockery of any individual who purports to act in the interest of justice, and most especially in the best interest of kids. And he makes a mockery of my children's emotional health when he meets with them without telling me, when he openly encourages them to dislike their dad as they report to me, when he gives them information about the litigation that is completely subject matter inappropriate for their age, without regard to what one of their parents thinks about that. and when he appears before the court and without fail attacks one of their parents, and without fail, over the course of a multi-year litigation, not one single time takes a legal position that is inconsistent, that is anything other than the legal position of the party who is responsible for his appointment. Makes a mockery of the notion of independence, of the statutorily mandated legal duty of independence, when he does not even speak with one of the two parents involved, both having their kids approximately half the time, both with facts that would be relevant to his consideration of the kid's best interests. When at best, when he does bother to show up for court proceedings, and sometimes he's got better things to do, at best only has 50% of the facts. Is at best only half-cocked. Guys, if we don't reform the guardian ad litem system, we should not be surprised that the same thing is going to happen over and over and over again. That absolute jackwad, unscrupulous, completely amoral human beings willing to put themselves above their clear legal duty to represent the weak of the weak, to do the hard work, to get the facts, to understand the best interest that they've been appointed to represent, to advocate for those kids. We should not be surprised at all that guardian ad litems will do as they do in my particular case, which is jack fucking shit. Besides show up when they want to, submit applications for payment, and take the legal position of the party that bought them. And make no mistake, that's what we're talking about. So, no serious discussion of reforming the family courts can be had without a difficult conversation of the reality of guardian ad litems. Their obvious potential for abuse and their rampant use in that way. And not just in my case, I'm not special, in countless other cases. Have a fight with another parent and want to seek litigation advantage? Buy a guardian ad litem. Weaponize your kids. And that's an option. I think that option should end. The guardian ad litem system is as evidently a system predicated in lending itself to abuse as is anything that I've ever seen in my 20 years of the practice of law. It cries out for abuse. So many parents and kids have been hurt through that abuse. It needs to stop. We need to stop it. We need to reform how we appoint these people, how we select them, and how we hold them accountable. And very frankly, that is not rocket science. Do we have the courage to institute those reforms for the betterment of the kids and families of Kenton County? I think we ought to find it. Thanks.